Welcome to today's program, Protecting Confidential Information and Client Relationships in the Financial Services Industry. Copies of the slides, a link to the recording, and the CLE verification form will be emailed to you in the days following the webinar. During the program, a CLE code will be read aloud, and you will be required to include this code on the CLE form. Throughout the webinar, please feel free to type your questions into the chat box on your screen. Now I'd like to turn it over to Jeremy Cohen and Kevin Mahoney.
Thank you, Colleen. My name is Jeremy Cohen. I am a partner in Seyfarth's New York office. I am a commercial litigator, and I've spent more than 2 decades litigating disputes in the financial services industry, including disputes involving trade secrets. I should be probably embarrassed to say this. I actually met my wife as the result of a FINRA arbitration, so my affinity for the subject transcends the office. With me is my partner, Kevin Mahoney, out of Chicago, and like me, he's spent most of his career litigating sophisticated financial and commercial disputes, and with a heavy emphasis on trade secrets. I went to the University of Michigan. Kevin went to both Penn State and Ohio State, but we've agreed for today to put any football rivalries to the side, at least for the next hour, so that we can walk you through the hot button issues involving trade secrets and protecting confidential information in the financial industry. So we thank you for spending some time with us here in the week before Thanksgiving, and without further ado, I'll turn it over to Kevin to get us going.
Thanks, Jeremy. Next slide. Just correct one thing Jeremy said. It is the Ohio State University. I was corrected on that very often. I'm sure he misspoke on that one, being a Michigan grad. We're going to talk about a few things today, starting with what is a trade secret. It's still a definition that is frankly difficult to pin down under the law, but we're going to talk about some of the common elements that we find in litigation that we're involved in, particularly in litigation in the financial services industry. We're also going to talk about some protective steps that financial services providers can use to protect trade secrets, including those that are important to their client relationships. We're also going to talk about FINRA and how the FINRA rules, particularly the FINRA protocol for broker recruiting, can affect what are sort of the standard rules for trade secret litigation. Next slide. As to the question of what is a trade secret, candidly, we are about 43 years out from the publication of the Uniform Trade Secrets Act. In that nearly half century, we are still not close to any sort of uniform, one-size-fits-all definition of exactly what a trade secret is. And the reason for that is determining what a trade secret is one of the more fact-intensive inquiries that you can imagine in litigation. Unlike other types of intellectual property, a trade secret is not like a patent, a copyright, or a trademark, where you can point to something that you've received from a government agency and say that is the intellectual property. A trade secret is much more amorphous. Something that may qualify as a trade secret in one type of industry under a certain set of circumstances may not be a trade secret in a different industry. Particularly in financial services, it's no surprise to anybody that customer lists are often regarded as some of the most important types of confidential trade secret information that an employer can protect. In other circumstances, a list of customers may not be a trade secret at all. We had a case here a couple of years ago where the industry was providing maintenance services to steel mills in northern Indiana. There's only a couple of customers in that industry. Everybody knows who they are. In that particular case, the court said, while customer information, the identity of customers may qualify as a trade secret elsewhere, under the particular circumstances of this case, it does not. It all really goes to the point that there is no one-size-fits-all definition of what constitutes a trade secret. It is going to depend on the facts of each and every case. Next slide. The statutory definition under the Uniform Trade Secrets Act, you can see it on slide there. As to the first part, what it really means is that a trade secret can be just about anything under the right set of circumstances. Both Jeremy and I have litigated cases involving what you might think of as the more traditional types of trade secrets: customer lists, pricing information, sales-related information, trading algorithms for electronic trading, things like that you might typically associate stereotypically as a trade secret. But we've also litigated cases that go far beyond. Things like marketing plans, manufacturing processes, It can be almost anything under the sun as long as it meets these two statutory prongs that are on the screen in front of you. What those really boil down to, next slide, is really just 2 points. A trade secret, first and foremost, and perhaps obviously, has to be a secret. It has to be something that's not generally known in the industry, it's not publicly available, and it gives your business some sort of competitive advantage. Something that doesn't always come up and is as obvious is that if something can be reverse engineered and it's out in the public, it's not a trade secret. That's what a patent is for. But if you have information, if you release it in the public such that somebody could take that information, reverse engineer it, that's not going to qualify for trade secret protection. The second prong is it has to be kept a secret. And what that means is that if you are the owner of that trade secret, you have to take affirmative steps to show that you have taken efforts to keep that information protected and keep it out of public hands. We'll talk about what some of those steps are in a little bit, but the test that is employed in just about every court is, were the steps that you took reasonable under the circumstances to protect your information? Next slide. I mentioned earlier the Uniform Trade Secrets Act, and that's been adopted by every state but New York at this point. That was, I think, first published back in 1979. We're only about 6 years out from the passage of the Defend Trade Secrets Act of 2016. That's the federal counterpart that created a private right of action for misappropriation of trade secrets under federal law. It's really not anything different than the Uniform Trade Secrets Act in terms of defining what a trade secret is, defining misappropriation, and examining the reasonable steps that have to be taken to protect trade secret information. When the DTSA was first passed, there was a lot of noise about some provisions in there allowing for ex parte seizures. In other words, there's a mechanism under the DTSA where you could get an order from a court without notice to the other side, directing the U.S. Marshals to go pick up, for example, a computer that contained trade secret information. 6 years out, I think it's fair to say that those provisions haven't really panned out. There's a few cases where that's been employed, but they are few and far between. By design, it's an awfully high burden to clear. I think really the more important aspect of the law, and the one that has really become important in the last 6 years, is that the DTSA creates a private federal cause of action. In other words, federal question jurisdiction. So before the act, where you may not have been able to get into federal court for reasons of diversity jurisdiction, if you have a trade secret claim, now you will always have an avenue to get into federal court, which, and we'll talk about this in a little bit, considering the changes to state level laws regarding restrictive covenant enforcement, if you litigated one of these cases, I think you'd likely agree that you would much rather be in federal as opposed to state court if you're litigating one of these claims. Next slide. Again, both statutes, the Uniform Trade Secrets Act and the DTSA, misappropriation is defined identically under each statute. First, you have to show that there actually is a trade secret, but second, you have to show unconsented disclosure or use of that trade secret by somebody who used improper means to acquire it or knew or had reason to know that it was acquired through improper means. That second prong, what that really means is that if you are the recipient of a misappropriated trade secret, you are going to be just as liable as the individual who misappropriated it in the first place. We'll talk about this in a little bit, but that creates a two-way street. One, it's a great hook for liability. If you've got a employee who left to join a competitor and took trade secret information, now you've got a cause of action against that competitor. At the same time, if you are hiring employees who bring confidential trade secret information into your firm and use that information in the course of their work, now you are on the hook for misappropriation under both statutes. Next slide. What are some of the remedies for that misappropriation? Well, first and foremost, and this is kind of a threshold question in most cases, is are you going to seek emergency injunctive relief? Are you going to seek an injunction right off the bat, or just seek money damages throughout the case? Those money damages can take a number of different forms. There's actual damages, normally in the form of lost profits, so lost sales, lost customers. There's also unjust enrichment, if a competitor uses your trade secrets to get a jump on their development time. But there's also reasonable royalty. That third one is one that is coming more in vogue, I think, especially within the past 5 or 6 years. Courts have realized that trade secret damages are often very difficult to prove. Under the DTSA, there is now this availability of what's called a reasonable royalty. So in other words, what a court will say is, if you are the owner of a trade secret, what would you have sold this trade secret for or licensed it for if you were a willing seller? And there's also now the avenue to recover that as damages under the DTSA. It also provides for potential punitive damages and attorney's fees if you can show willful and malicious misappropriation. However, that is also a two-way street. So if a court finds that you brought a trade secrets claim in bad faith, it can also award attorney's fees to the defendant. Next slide. We've talked a lot about the similarities between the two statutes. There is one important difference. Under the DTSA, there is required language under the statute regarding whistleblower protections for employees that if it's not in your agreements already, it definitely should be if you have non-disclosure agreements. If it's not in there, it doesn't absolutely negate the enforceability of the agreement, but what it does mean is that you cannot recover punitive damages or attorney's fees under the DTSA if it's not in there. Next slide.
So I'm going to jump back in here, and here we start to focus more narrowly on trade secrets in the financial industry. And we've identified three kind of broad categories of information that obtains trade secret protection in the industry. And what you'll notice is that each of these broad categories features the same word at the start of the category header. So we have internal customer lists, we have internal modeling documents, and we have internal opportunities and trends. And as Kevin said, there's two keys to establishing that your information is in fact a trade secret under the statutes. One is that it's a secret, and we get that from the internal nature of the information. And the second is that you take steps to keep it a secret, right? So again, that's why internal is really the key here. And we can see in particular in the financial industry where trade secret issues come up time and time again, especially lately in one case is with trading algorithms. And I guess you can go back in time and refer more broadly to trading strategies. But more and more algorithms and also source code underlying systems and platforms. Those have really become hot button issues. And then the other hot button, and this has been one from the start, is broker departures and with them any valuable customer lists and customer information. What's not protected as a trade secret are things that are not internal, things that are obvious or that are externally available. We can go to the next slide actually to talk about that. So here we see some examples of things that may not qualify as trade secrets because they are readily available or obvious and therefore don't fit within that internal paradigm that we talk about when we talk about our trade secrets. So social media posts and publicly available indexes and things like that are not going to qualify generally as trade secrets. There are ways to make publicly available information become a trade secret. And if we go to the next slide, we can talk about that. So compilations, this is an area that courts sometimes struggle with, right? Because what we're doing is taking different information from different sources and compiling it together. And if what you've done is just take publicly available, say, stock price information and put it on a piece of paper, that's not going to be a trade secret. The more that you add to it, the more that you bring in different inputs, even if you bring in multiple publicly available inputs and combine that or consolidate that into a compilation where you're adding your own unique insights, or if you're adding even just the sort of presentation of data is a unique or specific presentation that you use internally, then it may acquire trade secret protection. The more work that you do, and again, keeping it internal. So if you create a compilation and then release it out into the world, that's no longer a trade secret. But if you're using it sort of behind the scenes to operate your strategies and so forth, your compilation of information may well acquire trade secret information. And it really depends on, as I said, the more work you put into it, the more you kind of remove it from the public information and make it your own information, the more likely you are to establish trade secret protection. Another way you might do that is finding correlations between publicly available data. So if you're able to correlate an index with other publicly available information, you know, the weather on a certain day correlates with stock prices in a given industry, and you're the only one that's discovered that might be something that obtains trade secret presentation. So I want to start to talk about the cases that have addressed some of these issues in the financial industry. And as Kevin said, the way that these cases often progress is twofold. The sort of opening salvo is to go to court and seek an injunction. And that's a really important step in most cases, because one of the things that courts look to determine whether your alleged trade secrets are entitled to protection is the steps that you've taken to safeguard that information. And one thing that courts look at is how quickly you go to court to seek to get your trade secrets back if you believe they've been taken outside the protections of the company. So they look to see if you've taken immediate steps to get into court and to get injunctive relief. And then once you get past that hurdle, then, as Kevin said, you can start to look at damages. So if we go to the next slide. And these are just some illustrative recent examples. So this Acquiom case is one out of Colorado from 2 years ago, where the former employee took customer contact lists with them when they left the company, and the company went to court seeking an injunction, but the court denied the injunction because it found that the list contained only names, phone numbers of personal contacts that the employees had prior to joining the firm. There was not additional information that had been added, and what information was there was available to the public. So the court denied the injunction, but that wasn't the end of the case. What the court left the door open for was for the company to prove that information beyond just that basic information had been removed, had been taken to the competitor company. Things like insights, other information about habits, and so forth. That wasn't just the sort of name, phone number, email address. The court left that for a hearing, an evidentiary hearing and trial. So it became incumbent on the plaintiff to show that, in fact, that additional information beyond just the sort of basics and beyond the information that the employee had before they joined the company was what went out the door to the competitor. So there's one where, even though the injunction failed, the court didn't dismiss the case, sent the parties on for further proceedings. Next slide. So Elmagen is from last year in Pennsylvania, and it's sort of an interesting one. One of the ironies of trade secret litigation is you need to maintain the secrecy of your trade secret in order for it to get protection. But once you get to court, you're required to make a threshold showing of what exactly your trade secret is in order to establish that you have a claim. So you're kind of left a little bit between a rock and a hard place. On the one hand, you've got to keep the secret a secret. On the other hand, you've got to disclose something to the court. And this was a case about an algorithm. And what the court said is, you don't have to disclose the algorithm itself. You can describe it, and as the court put it, you can describe it in prose. Leaves open the question of whether you can describe it poetry. I think if you ask a lot of source code writers or algorithm developers, there is poetry behind what they do. But the point being that you don't have to actually put the trade secret out there on the docket in order to establish that it is in fact a secret. You can find other ways to sort of generally describe what it is that you're claiming protection over. The other thing of note in this case was that the court made clear that when we talk about whether something is generally known, we're not talking about lay people. We're talking about people in the industry. So in considering whether the algorithm at issue in this case was protectable as a trade secret, the court didn't look at lawyers, didn't look at lay people, the man and woman on the street, to say, hey, do you understand this algorithm? Could you have developed this algorithm on your own? It looked at what it called the reasonably sophisticated trader. And so that was the standard that the court in this case, and courts in most cases, will apply, is the reasonably sophisticated person in the given industry, and whether that person could use sort of common building blocks in order to design the algorithm at issue. So in this case, the court found that that the case had to go to a jury. It couldn't be decided by the court on its own, and it was up for a jury to determine whether the strategies at issue were generally known or readily ascertainable, whether the strategies had independent value due to their secrecy. In other words, were the trading strategies based on things like finding inefficiencies or other not widely known information that was unique to the firm. Also looked at whether the strategies were, the jury would have to decide whether the strategies at issue were sufficiently similar. The strategies being employed by the defendant company who is alleged to or who have taken the trade secret, whether the strategy as deployed by the employee at the new firm was sufficiently similar to what he had done at the old firm, and whether the defendant had access to those strategies. Although here there's kind of a straight line because it was an employee who had left from one firm to the other. But sometimes there are cases where you have a strategy being employed by someone at a new firm who wasn't necessarily an employee at the other firm. It might have been someone who had a different business relationship or was looking at something pursuant to an NDA in connection with a potential transaction or for another reason, and then copies the strategy. And what courts have said is that you can look at two factors, even if you can't prove actual theft of a trade secret because you can't show someone, emailing them a strategy to themselves or some other sort of actual, smoking gun evidence. If the strategy is sufficiently similar at firm A and firm B, and firm B had access at some point to firm A's strategy, that can be enough to establish misappropriation even without the smoking gun. So there are ways to prove these cases even without the sort of direct evidence. Courts will allow those inferences. Next slide. And very quickly, just through a couple of other recent cases of note. In Zabit, this case speaks to the issue of how you maintain secrecy. The plaintiff in this case was licensing its algorithm to another company, but it actually didn't include in the license an obligation to maintain the confidentiality of the algorithm. And so the court held that that was a failure to take reasonable measures to protect the secrecy, and therefore you couldn't maintain a claim under the DTSA. What the court did say, though, is that there could still be a claim for theft under common law theft doctrines, but just not a statutory claim under the DTSA. Geomet and Pinnacle are more general cases that kind of talk about the types of things that get trade secret protection. Don't need to spend much time on those. Smart and Associates also goes to the issue of whether information is properly protected. And what happened there was the plaintiff was entering into a confidentiality agreement with the other side, but it provided its information prior to actually signing the confidentiality agreement. And the court felt that that was a sufficient blunder so as to deprive that information of trade secret protection. So those are some recent examples of kind of maintaining secrecy and how those issues play in court. I do want to eventually talk about some specific issues related to FINRA proceedings, and FINRA has an entire regime that deals with broker departure and customer list issues, and I'll also talk about the broker protocol, which some of you may be familiar with. But before I get to that, I'm going to flip it back to Kevin for a bit.
Thanks, Jeremy. Next slide. I talked earlier about those two prongs of a trade secret. The first being showing that it is a trade secret, meaning that it's got some independent value to you. And the second prong being that you take affirmative steps to actually keep that information a secret. Next slide. But what does that practically mean under the circumstances? There are a not insignificant number of cases that end up getting kicked out on summary judgment because a court finds that even if something was a trade secret, that the owner of it did not take sufficient steps to protect it. As you can imagine, for a lot of plaintiffs, that is an awfully bitter pill to swallow, to be told by a court, well, yes, you have information, yes, it probably is valuable to you, yes, it was stolen from you, but you should have taken better care of it. That can be an awfully difficult one to accept, but it is sort of a low-hanging fruit and an easy way for a court to get rid of a trade secret claim, is to look at the circumstances and say you didn't take sufficient steps to keep that information confidential in a trade secret. Public disclosure of a trade secret is always going to destroy the information status as a trade secret. I have here the hotel printer. This is more of a nightmare scenario for outside counsel, but there was a case a couple of years ago where a plaintiff's attorney was staying at a hotel getting ready for a hearing and had printed out a copy or was attempting to print out a copy of one of the defendant's briefs in the case. And attached to that brief was an exhibit that was a document the plaintiff was claiming as a trade secret. Well, plaintiff's counsel is trying to print this out in the hotel lobby, can't get it to print, decides he's just going to do without it, goes off to the hearing. The printer was out of paper. So as soon as somebody came and reloaded it, of course, 4 or 5 copies of this brief came out with this trade secret document. Somebody picked it up, saw the name of defendant's counsel on it along with their phone number, called them up, explained what happened. Defendant's counsel pretty quickly put 2 and 2 together, brought it to the court's attention, and it ended with the court finding that this particular exhibit was no longer entitled to trade secret protection. The plaintiff's agent, their attorney, had not taken sufficient steps and had made it publicly available to anybody in that hotel lobby. That's a somewhat extreme case, but it goes to the point that intent doesn't matter. It doesn't matter whether or not you intended to disclose something. If it is publicly disclosed, then it's very likely going to lose its trade secret protection. Next slide. So what level of security is required? What kind of steps are reasonable under the circumstances in order to confer trade secret protection? You do not need to have each of your employees undergo a retinal scan every time they want to open up a document. That's not required. What a court is going to look to is what are steps that are reasonable under the circumstances, and a court's going to look to both steps that are taken on the front end to prevent disclosure of information, and also steps taken on the back end as to what a company does if it finds out that its trade secrets have already been misappropriated. We often run into situations where a company finds out that an employee has left and they were sending confidential information to their personal Gmail account, and they were doing it right before they departed for a competitor. And then we do a little bit more digging and we find out that this individual was sending confidential documents to their Gmail account for months or years. It turns out that other employees were routinely sending documents to their personal email accounts with no oversight and no warnings and no efforts on behalf of the plaintiff to stop it. Those are all things that a court is going to take into account when asking whether or not the company took sufficient steps reasonable under the circumstances to protect their trade secret information. Next slide. There's an acronym we remind all clients of ACE. It's auditing, creating a culture of confidentiality and enforcement. Auditing, the first part, is really just a matter of figuring out what exactly your trade secrets are, figuring out what information is truly critical and important to your business, what information really isn't that critical, and as far as the critical information goes, who has access to it, do they need to have access to it, and what steps are you taking as the owner of that trade secret to make sure that it's being protected in a number of ways. Next slide. Creating a culture of confidentiality goes far beyond just asking your employees to sign non-disclosure agreements. It really goes to ongoing training, not just during the onboarding process, but throughout the tenure of an employee, making sure they understand not only what confidential information is and why it needs to be protected, but the steps that they can take to protect it, particularly in the client service aspect. And we found this to be particularly useful in the financial services industry, where a lot of the confidential information you have is extraordinarily sensitive information about customers and their financial holdings. Explaining to employees, making sure they understand why that information is critical, not just to the company, but to protecting customer relationships and the damage that would result to customer relationships if that confidential information was improperly used. We've got the golden rule up there: treat others how you would like to be treated. Again, this goes back to if you have a newly hired employee and they are using confidential or trade secret information that they retained from a former employer, you are now very likely on the hook for trade secret misappropriation, which can be an awfully expensive piece of litigation that would be easily avoided. So making sure employees understand and certify in writing during the onboarding process that they understand that they are not to use any confidential information or trade secret information belonging to any third party, including any former employer. Marking things confidential, proprietary. We're not suggesting that every single document or every piece of confidential information that you may have needs to have confidential stamped across the top. But for your critical documents, that may be a good idea to let employees know and to eliminate any question as to whether or not something is absolutely confidential and should not be shared outside of the company. And during those training processes, making sure that employees know what the security protocols are, where they can find them, and who they can ask any questions to if they have any concerns or if anything is unclear in those security protocols. Next slide. Some of the baseline measures that should be taken to protect trade secret really include, first and foremost, agreements with your employees. If employees are going to have access to confidential information, they really need to be subject to a non-disclosure agreement. If they are not subject to a non-disclosure agreement, I can guarantee that a court is absolutely going to take that into account when examining the question of whether or not you, as the owner of a trade secret, took reasonable steps to protect it. That can be in the form of written non-disclosure agreements, as well as employee policies and handbooks, certifications that an employee has reviewed the policy and understands it, as well as during the exit process. We always recommend a written certification from the employee that they have returned and do not have any of your confidential or trade secret information. Confidentiality agreements with third parties is something that often goes overlooked. Jeremy mentioned a case earlier that involved a licensee where the licensee was not under a duty to keep the information confidential. This often comes up in the context of information provided to customers. So if you are going to claim pricing information as trade secret information, but that pricing information is freely given out to customers without any sort of confidentiality agreement, then that is definitely going to hurt your chances of establishing that that information is a trade secret if you ever find yourself in litigation. And then finally, network and facility security measures, things like password protecting your computers, requiring unique login credentials. Distributing materials only on a need-to-know basis is something that we've seen in courts, I think particularly in the past 4 or 5 years, pay particular attention to, asking whether or not information is really restricted to the individuals who have a reason to see it as part of their duties. In other words, is a critical customer list available to every single employee of the company, or is it only available to the team that services that client? Those are the things that a court's going to look at when asking whether or not you took reasonable steps to protect your trade secret information. And then finally, obviously, especially in the past couple of years, taking into account work from home considerations. With more employees accessing confidential and trade secret information remotely, what kind of steps do you have in place to make sure that information is being protected even if employees are not physically on site? Next slide. Again, these are sort of the baseline levels of protection that we would advise everybody to take into account, which is need-to-know basis, limiting access to employee use of non-approved cloud solutions. I mentioned Gmail earlier, but there's also Dropbox and all sorts of third-party FTP sites. If your computers allow for the use of cloud computing software, in other words, if an employee can take a computer and just drag and drop a file from a shared drive into Dropbox and send it off, then you may need to ask yourself, is that really something that they need to have the ability for as part of their job? And if not, is that something that can be restricted? The same thing goes for downloading and printing of files. We've got clients who go so far as to disable the use of any USB drives in any of their company-issued laptops. I'm not suggesting that every client needs to go that far, but again, these are the questions that you need to ask yourself about. If the employee has the ability to download or print materials, is it something that they need to have as part of their job? And if not, is it something that should be restricted? As part of those exit interviews I talked about earlier, again, we would always recommend getting a written certification from the employee that they no longer have any confidential information or trade secrets. That often goes a long way if you're seeking emergency injunctive relief from a court, to be able to show a court, look, they certified in writing on their way out the door that they didn't have this information. We've now uncovered evidence they do. That's something that a lot of courts will take into account in considering whether or not injunctive relief is going to be warranted. And then if they do have confidential or trade secret information, making sure that you take the appropriate steps to secure that information. You know, if an employee gives notice, consider whether or not allowing them to serve out an additional 14 days is something that's absolutely necessary, and what steps you may want to take during those 14 days to make sure that confidential and trade secret information is not being exfiltrated. Next slide. In the event that you do find out that confidential or trade secret information has been misappropriated, again, a court is going to look to what steps you took after being notified in examining whether or not you took reasonable steps to keep this information a secret in the first place. Forensic imaging and review, we often involve third parties who will go collect a computer. You would be amazed at the amount of information. I'm still amazed at the amount of information that can be gleaned from a forensic examination of a laptop in terms of USB drives being plugged into it, accessing cloud-based sites, use of Gmail, use of files, opening files in the short time before a resignation can give you a lot of ammunition if you're going into court seeking an injunction. Cease and desist letters, enforcement of agreements, and determining whether or not individual client notice is required. That middle bullet point is particularly important in the financial services industry. Again, in this industry, you are often dealing with confidential information that may trigger state or federal level data breach reporting requirements. It's important that you consider early whether or not such a statute has been triggered and whether or not you need to provide any notifications under any applicable law, because the penalties for not doing so can quickly escalate and become pretty significant. I'll touch on the last bullet point, which is preservation of evidence. You know, we often find that, you know, an employee leaves and immediately their email is shut down and their work computer is reassigned to another employee after being wiped. And then we find out a couple of weeks later that we have reasons to suspect that they took confidential or trade secret information on their way out the door. Your best evidence is now probably gone. Your best evidence was the form of that email, as well as what was done on their computer. So, yeah, I'm not suggesting that everybody needs to do a forensic imaging of every computer of every employee if they give notice, but there should be some steps taken to make sure that you're preserving at least an email account for a period of time after the employee leaves, so you can be sure that no information was taken and nothing's being used improperly. Next slide. Legal options, and we've talked about some of these already in terms of injunctive relief, but there are a number of either breach of contract or civil claims you can bring, whether it's under the Defend Trade Secrets Act, the Uniform Trade Secrets Act, the Computer Fraud and Abuse Act. In light of some recent Supreme Court guidance that's really restricted to instances of external actors coming in and stealing trade secrets as opposed to an internal actor, but it is still an option in some jurisdictions, as well as common law claims like breach of fiduciary duty and the duty of loyalty. You know, we talked about some of the damages and the ability of injunctive relief. One question that comes up is the doctrine of inevitable disclosure. For a long time, and in I think most federal circuits, there was this doctrine recognized that if you had an employee with confidential information who left, even if they were not under any restrictive covenants, could they still be prevented from working for a competitor if the nature of their employment at their competitor would mean that there's no way they could not use confidential information? They called that the inevitable disclosure doctrine. Under the DTSA, there is no more inevitable disclosure doctrine. The DTSA specifically says that it cannot be the basis for an injunction keeping somebody out of employment. However, it's still an available remedy under state laws. So if you have, I'll give an example, Illinois. Illinois still recognizes inevitable disclosure doctrine under its State Trade Secrets Act, but not under the DTSA. And often those two claims are filed in the same lawsuit. So inevitable disclosure, not an option under the DTSA, but it is still an option under some state versions of the Uniform Trade Secrets Act. And then finally, criminal referrals. You know, especially in cases of customer lists, and especially with an internal actor who, for example, leaves and goes to a competitor, the answer you're going to get for most of those is that it's a civil matter. You're not going to find criminal options. But for other types of trade secrets, things like trading algorithms, more technical-based trade secrets, there are options for criminal referrals and potential criminal liability for misappropriation of trade secrets in those circumstances. Next slide. Finally, and we could spend an entire day on this, but if you have agreements with your employees that have non-disclosure provisions, it's very likely, at least for a lot of the attendees, that you also have post-employment restrictive covenants, whether it's a non-compete or a customer non-solicit. Over the past 8 or 9 years, there has been an absolute sea change at the state level as to state laws addressing the enforceability of those restrictions, whether it's providing a notice period where the employee has to be given a certain number of days to review an agreement before signing it, income thresholds, the length of restrictions, certain language that needs to go into an agreement. If you have an agreement governed by Illinois law, if you do not advise the employee somewhere in writing to consult with an attorney about the restrictions, then your post-employment restrictions are no longer enforceable, which has been a surprise to many clients. So if you have an agreement with post-employment restrictions and they haven't been tuned up in a while, now is probably the time to do so, particularly with these problem jurisdictions that I've listed here: California, Colorado, Washington, Louisiana. And those are the jurisdictions that now not only have particular laws about post-employment restrictions, they also require you to use domestic law as to those agreements. So if you are an employer in Michigan and you have employees in California, you cannot have an agreement with those employees governed by California law. Governed by Michigan law. It has to be governed by California law. That's now the case in Colorado and Washington as well for customer non-solicits. New Jersey is actually considering a similar bill, although it hasn't been enacted yet. So again, if you haven't had your agreements looked at in a while, now is probably the time to do so. Next slide.
So as promised earlier, I want to talk a little bit about FINRA, but before I do that, for those of you who are here for the CLE credit, this is the time when we'll give that out and watch our attendance numbers go down. The code is SS, as in Seyfarth Shaw, 8734. Again, SS, as in Seyfarth Shaw, 8734. So to pivot now to talking about some FINRA specific issues, as I mentioned earlier, one of the perpetual hot button issues is when brokers are on the move, when the big producers leave with their million or in some cases billion-dollar books of business. If you read Advisor Hub, it's every month, if not every week, there are big teams on the move. Just last month, they reported on a billion-dollar team in Rhode Island moving from UBS to Morgan Stanley, and I think Rhode Island is somewhere where $1 billion still counts as real money. So this is an issue that's always at the fore. And FINRA will often be the venue where disputes that arise in the aftermath of broker departures are resolved. So if we go to the next slide, FINRA provides a set of both procedural and substantive rules that govern when there are disputes about brokers leaving or even before there are disputes. So there are rules that say that you cannot prevent account transfers. There are rules that require disclosure of information to customers when a broker moves and the broker wants to bring his or her clients with them. So and by the way, the mandatory disclosures in that circumstance are not very complex or sophisticated. It's really just advising the customers that the broker may have a conflict of interest, may have had incentives to move that may not align with the customer. They're really customer protection type of disclosures. They are all of 2 pages long, and you can find them on the FINRA website. But beyond those rules, when there is a dispute, FINRA's dispute resolution provisions get triggered. very often when you're dealing with broker departures. Um, and the way that they often work, there's a specific FINRA rule that authorizes parties to go to court to seek an injunction at the outset, while also filing your FINRA arbitration if you're required to pursue the merits of the claim in arbitration under the FINRA code. So you go to court, you get your injunction. If you do, then FINRA rules require a FINRA panel to convene within 15 days to decide whether what the court has entered as a temporary injunction should be extended into a permanent injunction. A lot of times the reality is that if you get the temporary injunction in court, the parties will agree on the scope of a more permanent injunction that will last through the end of the merits hearing, but not always. And so FINRA does have this emergency provision that's triggered and requires hearing in 15 days. We've listed here just one recent example out of Missouri where departing representatives solicited their customers. The UBS went to court and was able to get a stipulated order agreeing that there would be no solicitation while the FINRA proceeding played out. So they first went to court. Based on the showing in court, the defendants entered into that order, which had to carve out they could return unsolicited phone calls. They just couldn't solicit their clients. And then they went to FINRA, and it's pending before FINRA now. We'll go to the next slide. This just shows some of the differences between court and FINRA and why one forum might be preferable to the other. The caveat being you don't always have a choice. Certain disputes in the industry are mandatory to go to FINRA. I think these are largely self-explanatory, but the one that I do want to mention is the last one under FINRA litigation, which is the concept of arbitrator justice. Sometimes when you have FINRA arbitrations, you get panels who are people from the industry, and they may form defined views that are more often based on sort of their feeling of what's right, what's just, or maybe what angers them. That may not be quite as closely tethered to the law as you'll find in court. Not always, but sometimes. And so you do run the risk or the possibility of having an arbitrator who just doesn't like the facts of a case and might kind of fit a ruling to their view of what they think is right rather than what the law requires. And we're going to see that in just a second. So, but I want to move on to the next slide. So I want to talk about the protocol for broker recruiting, which some of you may be familiar with, and we can go to the next slide. So the protocol for broker recruiting, as you can see, goes back to 2004 when Citi, Merrill, and UBS entered into this agreement that basically said, hey, we're going to allow our reps to move from one firm to another under certain sort of confined circumstances. And if the reps are moving from one signatory to another, they can take with them certain information. The protocol itself is, again, not a very long document. It's 2.5 pages, and it's administered. It used to be administered by a private law firm. It's now administered by a forensics firm. It's open to any firms in the securities industry, any broker dealers. It's voluntary to join. You can withdraw at any time on 10 days notice. And in fact, some big firms have left in recent years, including founding members like UBS, who've apparently determined that it's not as valuable to them to be part of the protocol as it is to operate outside the protocol. What the protocol provides, and we can go to the next slide, is that when a registered rep leaves a firm to go to another protocol member firm, they can take client name, address, phone number, email address, account title. You can solicit the clients. Once you get to your new firm, you can solicit clients from the former firm. And if you comply with those things and you don't go beyond that, then your former employer cannot go after you or your new firm for damages or injunctive relief. There's a couple of specific rules that relate to teams. So if a departing rep is a member of a team and the whole team isn't moving, they can only take with them what the team agreement allows. But if you've been part of a team for more than 4 years, you can take client info from any of the clients of your team. If you've been part of a team for less than 4 years before you leave, you can only take client info for your specific clients. So that's one of the wrinkles when it comes to a departing member of a team within a protocol member firm. I'll go to the next slide. So FINRA is generally the forum for protocol disputes, although for reasons we've discussed, they may start in court. There may be reasons that they end up in court altogether and never get to FINRA. But generally, FINRA is going to be the place. The protocol applies only as between two signatory members. So if a rep leaves a signatory firm to go to a non-signatory, the protocol doesn't apply. Converse also true. Going from a non-signatory to a signatory, it would not apply. The protocol does not necessarily trump company or team agreements, as I mentioned. So there are some limits to what it can do, and that it generally will apply when it's the prior employer going after the employee. There's limits about what you can do against another signatory firm. There can be quite grave consequences for going beyond what the protocol allows when a rep moves from one signatory firm to another. And there can be quite dire consequences for breaches of other relevant provisions, right? The protocol doesn't supplant the law. It's in addition to, so a violation of the protocol might also be a violation of the DTSA. It might also be a violation of common law duties, like fiduciary duties or duties of loyalty. And just earlier this year, there was a cautionary tale, and sort of I'm going to leave you with this scary, eye-opening case that emanated out of Arkansas. If we go to the next slide. So it's a case called Stevens, and you've got the FINRA case number there, and you can actually find the case and you can find the award. And this is a case where a handful of brokers in Arkansas left to join a new firm. They left all at once, and it appeared that they had been the brokers had been soliciting other brokers to join them in breach of non-solicitation agreements. It also emerged that they had started contacting clients before they left to join the new firm in violation of the protocol, and that they took information with them that went beyond what the protocol allowed. So the prior firm asserted every claim they could think of, and I've listed some of them here. The arbitration, people think that arbitration is often more efficient and quicker than going to court. This is a case where there were 12 pre-hearing arbitration sessions and 72 hearing sessions spanning, resulting in a 35-page decision, and also, as you can see, resulted in quite substantial damages totaling over $18 million. And what the court, or rather what the panel found, was that these brokers had violated all sorts of duties and failed to maintain confidential information in addition to breaching the protocol. What I find kind of interesting is there's a equally lengthy dissent, and that's pretty rare in my experience in arbitrations. That most often you get unanimous decisions, but this is one where one of the arbitrators felt compelled to take pen to paper and write a lengthy dissent. And the basic conclusion was that everything that the departing reps had done is just sort of how business gets done, that people leave and you can take your clients with you, and felt that the damages were not merited, let alone $18 million worth. Now, once the award was issued, the claimant, Stevens, went to court in Arkansas to get that award confirmed so that it has the force of a legal judgment. The respondents, the Benjamin F. Edwards and Company, and the brokers that left, they opposed that, and they sought to get the arbitration award set aside. And it's very hard to get an arbitration award set aside unless you can show essentially overt bias on the part of the arbitrators. A court is going to confirm an arbitration award, and that's what happened here. And that's another point about arbitration, is you lose your appellate rights, or you have only very narrow appellate rights. And so that was back in August, and in August of later that month, the the parties filed a satisfaction of judgment indicating that the $18 million judgment had been paid, all going back to the brokers making some phone calls and otherwise laying groundwork for their move before they actually completed the move. And as I said, arbitrator justice doesn't necessarily align with the law. And if you read the lengthy award, it kind of permeates the award how dimly the two arbitrators who ruled, who entered the $18 million judgment, viewed the conduct by these folks. Even when there was a fairly reasoned dissent that suggested the conduct maybe wasn't as bad as those two in the majority believed. So that's an example of arbitrator justice resulting in a pretty whopping award. So that's the scary thought I want to leave you all with. I'm going to, on that, turn it back to Kevin to close on a more optimistic or productive note.
Hopefully optimistic. Next slide, please. Thanks, Jim. I think there's one thing we want to emphasize at the close of today is that whether you're in FINRA arbitration or a more typical lawsuit, litigation as a means of protecting trade secrets, while sometimes inevitable, is a rather expensive way to do it. So the things that we talked about earlier about taking both technical steps as far as computer access to trade secrets, conducting an audit of your trade secrets, certainly requires a little bit of an investment up front, especially in terms of time, but I think you're going to find that as opposed to being in litigation over a trade secret, it's considerably cheaper to take those affirmative steps up front to try and curtail misappropriation use of your trade secrets rather than trying to fight that out in court or through FINRA arbitration. Next slide. If you haven't already received it, we do provide a 50-state desktop reference. It's available on the Trading Secrets blog published by our firm that talks about some of these updates. The 50-state desktop reference is of particular interest this year, especially because, as I mentioned earlier, we've just got a host of new state laws addressing the enforceability of post-employment restrictive covenants. And on the blog, we examine all sorts of recent cases, including some of the ones that Jeremy spoke about today. If anybody has a question, next slide, you can type it into the Q&A. We already had one, which is, if you request a certification of return of confidential information upon exit by an employee, is it problematic if you never obtain a signed copy, as it is often challenging getting former employees to engage? Great question, completely understandable about former employees. I would say that it depends on whether or not this is an employee that you intend to take action against and the circumstances under which the employee would not sign the return slip. So in other words, if you've got an exiting employee who says, I can't sign that sheet because I think I do have information, and you never obtained a signed certification, you take no action, and a year later you find out that the employee is using confidential information, that's certainly going to be an issue, and that's going to be a problem because the employee advised you as to why they wouldn't sign it. If you just have an employee who is completely non-responsive, refuses to sign the document, is that a problem? I think in our experience, it's less of a problem than just not asking for any certification in the first place. You're not expected to file a lawsuit against every employee who refuses to sign a certification on their way out the door, but if you're never asking employees in the first place on their way out to certify and make sure that they don't have this information, I think generally that's going to be a lot more problematic in litigation than having a few employees who just won't engage and refuse to sign that on their way out.
And if it turns out that that employee has taken information, it can be a pretty helpful and useful rhetorical point in your litigation papers, that, oh, we put this in front of the employee and he or she flatly refused to sign it because to do so would have been to certify to something that was false. And you can sort of prove your case or at least start to prove your case inferentially through that means. Seeing no other questions, I think we want to thank everyone again for joining us today. We wish everybody happy, healthy Thanksgiving, and that is all.
Thanks, everyone.